Good evening, Crime Talk aficionados. Thank you for joining us here on Crime Talk on our show Tuesday night, affectionately known as After Dark. Now, a lot going on this week and part of last week as it relates to the Lori Vallow trial. So if you've seen the videos that we put up quite recently, we've talked about it. And the video that we put up today regarding Lori Vallow also would like a continuance, just like Chad Daybell, her husband. Although her husband, or at least her husband's lawyer, refers to her as Lori Vallow, as I have been referring to her the entire time, because it was obvious to me from the beginning, particularly Chad Daybell's attorney, Mr. Pryor, wanted to keep Lori Vallow so far away from this case so that the two of them would not be together. And I think he may just get his choice to do that. A lot to talk about. So I want to thank everybody for joining us. For those of you who have not joined us before, my name is Scott Reich. I'm a practicing criminal defense attorney. Although normally we have a suit on, I have one of those rare weeks where I have no court. It's beautiful. We had something set. It got continued. So I have a light week in the office and, starting to feel like fall. So we just put on, business shirt and a vest. But so we've been looking at the Lori Vallow stuff. So let's take a look at first what was filed. It was actually filed October 3rd. Today's technically the 4th. So yesterday it was motion to continue the trial, to toll time limits, and to stay the case. Coincidentally, it wasn't a waiver of speedy trial, but it is a tolling nonetheless. And the thing that we talked about is, look at that big old redaction there. Look at that. That's the big old redaction in this entire thing, which basically is the whole basis for the motions. But remember, okay, and this motion finally, this was put up just yesterday and was made available for public access. All right. Actually, I take that back. It's not up on the court's public access system. We obtained it through other means, but it's still been redacted. And so it's still just frustrating, but at least they're hopefully making a little bit of progress in making this stuff available so that the public has access to it. And the big old paragraph 2, completely redacted. Paragraph 3, because of redaction, the defense asked for a toll on the time limits in which to comply with pretrial orders, a continuance of the pretrial date, and a continuance of the trial date. And what are they trying to do? Well, it's quite clear that they reference a little earlier in their motion, Idaho statute 18-207, where it specifically says mental condition shall not be a defense to any charge of criminal conduct. Okay, that's really basic saying not guilty by reason of insanity. Okay, now some states have not guilty by reason of insanity. Most states do, not all. Idaho is one that says, no, we're not going to consider it. But when you look at the Idaho statute, you really think, God, why don't you just do, not guilty by reason of insanity, because you get the same result either way. So in this particular statute, and what it looks like they're waiting upon or for is the receipt of medical records so that they can properly give notice under this particular statute. And specifically under statute, it says nothing herein is intended to prevent the admission of expert evidence on the issue of the state of mind, which is an element of the offense subject to the rules of evidence. And it basically says that you have to give notice, you have to lay all this proper foundation, and basically says, mental condition can come in. It says raising an issue of mental condition in a criminal proceeding shall constitute a waiver of any privilege that might otherwise be interposed to bar the production of evidence on the subject, and request the court shall order the state's expert shall have access to the defendant in such cases for the purpose of having its own expert conduct an examination. So if you can present, Idaho says we're not going soft on crime. We're not going to give people with mental health issues any kind of a break. So no, not guilty by reason of insanity. Because we've talked about that before on the show, on other cases. An NGRI plea is really, and it's an affirmative defense, like self-defense, saying, yeah, I did it, but I was justified in doing it. NGRI is saying, I did it, but I was crazy. I couldn't form the mental intent, right? And so they're saying, well, you can't consider that, but then you can. So if a jury truly believes someone couldn't form the mental intent because they were crazy, then you get a not guilty. But then the statute reads and says, hey, if somebody, is found guilty and we find that the defendant suffers from a severe and reliably diagnosed mental illness or defect resulting in the defendant's inability to appreciate the wrongfulness of his conduct or to conform his conduct to the requirements of the law, guess what? NGRI. Then they send him off to the state mental hospital and not to be sent to a prison that doesn't have some sort of treatment. So it really comes right back to the same thing. You can call it what you want, but really it's kind of an NGRI backdoored in the Lori Vallow case. So what does all this mean? Does it mean that Lori Vallow is going to get a continuance? My guess is yes. Do I think that there's going to be a trial on January 9th with the beginning of jury selection, even though the jury commissioner up there in old Ada County has probably come this close to sending out juror summons so that all the potential jurors can show up on various times and designated times to do that. And so I think the court actually had an order of October 14th that said, hey, you better submit all this stuff. So what does that mean? My guess is, and obviously I'm not the judge, Judge Boyce, but so far Judge Boyce has not seen a motion to continue that he has not granted or a motion to continue that he has not loved in some way or another. And then you have the motion filed by John Pryor the other day in regards to his motion to continue. And let me grab from my stack of stuff here because it is there's just a ton of stuff, but basically what Mr. Pryor says is I'm ineffective. Sure, I've been working on this case nonstop for 16 months since the murder charges came down, and probably another year before that, when they had the whole disappearance and then the witness or the evidence tampering, things like that, the abandonment of the children, the ones that originally brought this case forward. And so here we are. 2 years, almost going on 3 since the kids finally disappeared, and almost nothing has taken place. I'm not even sure that John Pryor is going to stay on this case. Think about it. So far, let's just do some quick numbers here. Okay. I don't really know what the going rate is for attorneys there in Idaho, but let's just say you're a fair, reasonable, competent attorney. Let's just say your hourly rate, let's say $400 an hour. Okay. It's a reasonable rate. New York, I think they charge up, some attorneys can charge up to $2,000 an hour, I've heard, or more. It's crazy. But let's go 400. Let's just say he works a normal day. So that's obviously times 8. That's $3,200 an hour. He could have worked on this case nonstop with the amount of discovery that's coming in, reviewing it, getting up to speed, which he says he's done no work as it relates to getting ready for the death penalty phase thus far because he's been too busy worrying on the factual allegations and the pre-indictment issues. All right. So let's say $3,200 a day times 5 days, right? They've had this case how many months? 16 months. Let's see. So what do we say? 3,200 times 5 equals, that's $16,000 per week. that he's building on this case. Now, I don't know if Chad Daybell is a wealthy man. Who knows? His house looked nice enough. It looked humble enough. But I don't know. Maybe he was selling lots of those books and he has tons of money stashed away. But let's just say $16,000 instead of saying 52 weeks in the year. Let's just say he worked on it 16,000 hours per week times, let's just say 45 weeks because he didn't do anything. That's $720,000 basically for a year that he's had it working on this case. I mean, I don't think he wants to work for minimum wage. He wants to seek co-counsel. He's privately retained. He can't find anybody that can come in and co-counsel the case. Why not? My guess is because no one wants to work for free. No one wants to work for free. I doubt Mr. Pryor does. I doubt that any co-counsel does. And I hate to throw this out here. I hate to say it. But hey, if we're going to have a total reset here, now is the time to do it. We got Lori Vallow saying, I want to stay the proceedings because I want to give proper notice of this mental health defense that I have. And frankly, they got a pretty good defense to that because she was found not to be competent. And I bet there's some really good stuff in the health records for Lori Vallow to show, pursuant to the statute, using the statute's language, not mine, that somehow she suffered from a severe and reliably diagnosed. They were reliably diagnosed. They were the state's doctors, right? So suffers from a severe and reliably diagnosed mental illness or defect. My guess is they said that she suffered from something, some sort of delusional disorder, resulting in the defendant's inability to appreciate the wrongfulness of her conduct or to conform her conduct to the requirements of the law. What does that mean? That means she's crazy. That means not guilty by reason of insanity. I know they don't have it, but that goes directly to the element, right? Go back and look at the elements under the statute as it relates to murder in the first degree in Idaho. That the defendant, on or about the date and place charged, knowingly, you knew what you were doing, aware of your conduct. Basically, it's the complete opposite of this, that you appreciated the wrongfulness of your conduct. And if you don't, and you think, well, I'm not killing my own children, I'm not asking my brother to kill my own children, I'm not engaging in a conspiracy to have my children killed, then guess what? If you really look at that element, that'd be a not guilty, wouldn't it? So I think Idaho may have outsmarted themselves here, but we'll have to wait and see. So if now it's time to going to be a reset, now is the time to do it. And what I mean a reset is, listen, if I was Judge Boyce, I'd set that hearing for October 13th. I'd get everybody in here and I'd say, Mr. Pryor, I'm going to ask you once and speak now or forever hold your peace. If you do not have the means and the resources to go forward to do this case, now is your opportunity to get off this case. And I'm giving you that opportunity now. If not, guess what? Don't come back here again and say, Judge, I haven't been paid. It's involved more work than I expected. Therefore, I'm going to come back at a later date and move to withdraw. If I was a judge, I'd say, listen, Mr. Pryor, it was your one chance. Take it or leave it. I'm willing to appoint Chad Daybell, probably the public defender's office or another court-appointed counsel who's death qualified to do this case at state expense. Mr. Pryor, you just walk away because I'm not going to come back here in 6 months or 8 months or a year from now and you say that you're not ready to go or that you haven't been paid and you want to withdraw. Not going to do it. Then you look over there at old Mr. Archibald for the defense for Miss Lori Vallow, and you basically say, all right, Mr. Thomas, Mr. Archibald, I'm going to ask you something here. Talk to your client. Does she want to waive speedy trial, or have her withdraw her guilty plea. I guess we could toll it. Doesn't matter. Stop it, toll it, withdraw your guilty plea. Do something so speedy trial is stopped and say, listen, gentlemen, I know technically under the statute, you were not allowed to work on this case until Lori Vallow was deemed returned to competency. Look at him square in the eye and say, I'm not going to give you an eternity, but how much time do you reasonably need to be prepared to defend this case? Is it 6 months? Is it 8 months? You let me know. But we're going to set a trial date and we're going to go. Let the appellate record be damned, but we're going to go. This case needs to move forward. That's what I would do as I was Judge Boyce. I would lay down the law, because right now his nice guy approach has been failing miserably, in my humble opinion. I have seen death penalty cases get to trial in less time. The prosecution had to put everybody on notice when they indicted. They say, or within a short amount of time, saying it's going to go death. Everybody knew it was going to be death, and people should have been working and preparing. I mean, I get it. I'm assuming Mr. Pryor has a practice. He has other things going on, but I don't think anybody anticipated how big this case would have ultimately come. But he knows that there's been so much discovery turned over. I mean, we're talking terabytes of information that you have to go over. You have to have experts look at it. I mean, it seems like these days, when it comes to cell phone data, we spend more time with cell phone experts these days telling me, is this accurate? Tell me what I'm missing. As an attorney, you just don't know those types of things. You have to consult the expert. And it sounds like, according to Mr. Pryor's motion to continue, it is just not good. And then we find out, this is on page 25 of Chad Daybell's motion to continue, filed by his attorney, John Pryor. The investigation into the merits phase remains ongoing. The prosecution has recently made a request for additional DNA testing, and several discovery items still have not been turned over to the defense. Though the prosecution has no less than 5 attorneys working on this case, 5 times the manpower of undersigned counsel, they have not yet complied with their discovery obligations. Okay, why? Why is the prosecution, with trial less than 4 months away, right? We just started October. So we got October, November, December, 3 months away. 3 months away. And the prosecution is still just now doing their testing on DNA, requesting DNA. And maybe it's going to be expedited because there's a trial date coming. But either way, what have they been waiting for? They have 5 attorneys. The prosecution should be jumping up and down and saying, we're ready to go. I'd be very, very concerned for the people of the great state of Idaho if the prosecution says, fine, go ahead and agree to their continuance. And they may say, well, we're going to go ahead and go along with this, judge, because let's face it, it doesn't look like Mr. Pryor is going to be ready, and we want him to be effective under the 6th Amendment of the United States Constitution, right to counsel. It's presumed that you have effective representation. Then you got Lori Vallow's attorneys who have said, I don't think I'll be ready to go. We won't be effective, but we have to do what we can within the 6 months, which means lots of long days, long nights, and lots of weekends preparing. You get done. The job expands to the amount of time given. And the prosecution dumping stuff. I had a homicide case once where we were ready to go to trial, and the DA was like, oh, we're going to dump all this new discovery on you. Do you want to take a look at it? It was all hands on deck. We went through everything, thousands of pages of discovery over the weekend. And we showed up for our pretrial conference and said, Judge, we're ready to go. And it was a not guilty. Okay. The job expands to the amount of time given. Remember that, Judge Boyce. You give them 8 months, they're going to take 8 months. They're going to dilly-dally around. You need to put some get a big stick out so that they know they're going to get a big stick across the forehead if the attorneys cannot be prepared and make this trial go in an appropriate time. But I would be very, very surprised. October 13th is coming up rather quickly. And I have to maybe look at the official CrimeTalk calendar here, because I'm thinking this is maybe one of those hearings that we need to go to. October 13th is a Thursday. Yep. And let's see here. Let's look at our Wednesday, because it's going to be, I think it's in the afternoon, but we could fly out in the morning. Well, I got one thing. Wait, what is that? Yeah. I got one thing set. We could probably make it work. That's what happens when you have other attorneys that work here for you in the office. You can make things happen. We may have to go there just to see the tone of the proceedings. Maybe I am misjudging all of the characters involved here, but I think Judge Boyce needs to stop being Mr. Nice Guy, and let's get things done. Let's move this case forward. It has been going on far, far too long. And I mean, I don't even know where to begin. And then we got Lori Vallow's attorneys don't want cameras in the courtroom. Then we got Chad Daybell saying, I want cameras in the courtroom. Talk about conflicting already. And ultimately, cameras are the discretion of the judge. But, I mean, this is a case that needs to be televised. Okay? I would think the people of the state of Idaho, and when I say the people, I mean not only the good people of the state of Idaho, but the prosecution, who, you know, represents at the top of the caption, the people of the state of Idaho, plaintiff, that they would want this broadcast to say, hey, listen, if there's a couple of people out here that you're going to do harm to your children, guess what? We're going to find out about it. We're going to seek justice, and we're going to hold people accountable. And don't mess with Idaho, right? Like the old don't mess with Texas. They should say, don't mess with Idaho. Nobody's going to mess with our kids here in Idaho. And if you do, we're going to send you to prison for a long time. And we've got competent prosecutors, and we're going to do that. We'll have to wait and see. I mean, I'm telling you that I have said this before, and you can go back and look at the previous videos. Now, I've talked about this. Excuse me. Didn't mean to bump my mic. Early on in this case, when the children were missing, remember, it was the abandonment of children case, and they were charged with minor felonies. Okay. This is why it's so important for people to be truthful and candid with your attorneys. If the defendants, Lori Vallow and Chad Daybell, had talked to their attorneys and said, you know what, you're not going to believe it, but it was crazy. We got a little carried away. We thought we were these gods, and maybe some dark spirits came along. The kids, but guess what? They're no longer with us, and maybe they're buried at Chad's house. But let's not get into those details, right? Okay, so what you're saying is they're dead. What'd you tell me? Yes. I would think that a experienced criminal defense attorney would march them into court as quickly as they could and say, Judge, my client's going to plead guilty to the charge. Be with it what you may. Where are the children? Doesn't all knows, abandon them. That's it. Plead them guilty, right? You say, Scott, why would you do that? Why would you do that, Scott? Well, if I was their defense attorney, the reason I would do that is there's a theory under the law called compulsory joinder. Okay? And it basically says, hey, Mr. and Mrs. Prosecutor out there, if you're going to charge somebody, you're going to bring all those charges at one time. Okay? Obviously, the abandonment, and then the tampering with evidence, and then the homicide charges, they're all linked together, particularly as it relates to the children, right? So they're facing low-level felonies. Go in there and plead them guilty. Okay? Because it's not fair under our system of laws if you prosecutor gets to piecemeal the case. Think about it. Let's say you're charged with a traffic offense, right? Maybe you're charged with a DUI. And you're charged with a DUI, and things don't go well for the prosecution. They're like, man, we really just don't like this guy. We're going to bring new charges. We're going to bring that careless driving and the reckless driving and the turn signal. Okay. You had your shot. Same thing. Once had a racketeering case where people, big crime ring. Okay. And crime ring in county A, B, and C. Person gets arrested in county A for stealing stuff all around the jurisdiction. County C knows that A and B are working together to put their cases together. Client pleads guilty in A. Say, hey, it's all one criminal enterprise. You didn't charge B and C, even though these guys knew about it. You pled him guilty. You allowed him, you pled him guilty, and you should have said, no, don't do that because there's more charges coming down the way. And the court said, yeah, you can't do that. Those other you had your chance. You were going to bring this. Can't bring those in. You can't piecemeal it. So if an experienced criminal defense attorney, and I've mentioned this early on, said I'd go in and plead him guilty right now. That's why it was a conversation we had about being completely candid with your attorney. So they go in there and say, yeah, you know what? The kids, they're gone. They're gone. Yep. And the attorney's going to say, okay, right. It sounds like a conspiracy. Or at a minimum, it sounds like under a theory of complicity, which means you aided, encouraged, or assisted somebody in the commission of an offense. You can be found guilty just like you did it yourself, right? Or maybe an accessory after the fact. Maybe you dug up holes or something along those lines. Any of those things. And if you know about it, right, you go in and you plead him guilty, right? I've had cases like that where, bad barroom fight goes bad. Hit somebody, they die. They're going to charge murder if the guy dies. Go in and say, we're pleading guilty now to the assault charges. Oop, guy dies 2 weeks later. Oops, sorry. Probably could have been murder, some sort of reckless manslaughter. Oh, sorry. Already pled guilty. But they didn't do that. And I don't know if their clients were not being completely candid with them. I don't know if, who knows? I don't know. I don't know if they haven't been completely candid with their clients, or if they just messed it up. I don't know. Maybe they didn't think about that. But I mean, we deal with that all the time. Like, ooh, this could get really bad. Let's plead him guilty now, right? Like, why did they not charge this based upon what I know? Oh yeah, go in and plead him guilty. Then let's say they pled him guilty to the abandonment of children, or even to the tampering with evidence charge, low-level felonies, a couple of years in prison, worst case scenario. And then they said, oh, now we're going to charge you with murder. Oh no, it's all one series, one act, all related. You had your shot, prosecution, but the prosecution would have been forced more than likely to say, we're going to dismiss the charges so they can't plead guilty because we're going to bring all these charges at one particular time. Hopefully that makes sense. We'll see. Let's take a look at a couple of questions here. Girl drink drunk, not nice to lie. I don't know if that was referring to. Pending money. Let's see here. Let's see here. If LDS is okay. And we're not going to get into the whole LDS thing. I understand a lot of people, obviously this is Southern Idaho. A lot of people think the LDS church, and don't get me wrong, when Frank and I jumped in CrimeTalk 1 and went over there, the highest building, the largest building was the Mormon temple. It was very obvious that the Mormons, the LDS church, had a lot of influence there. I mean, I think one could say it's like when you go to Salt Lake City, the first thing that jumps out at you is, what a very, very clean city this is. That's very much the way it was there in town. It just struck you as how clean it was, which is a good thing, right? But a lot of people saying, oh, the LDS, you know what? I don't have any evidence to support that. So I don't want to get down that little rabbit hole too much. It could be true. Sure, I'm sure the LDS church, doesn't like when there's factions that go off and make the bigger group, look not so great, so to speak, but I don't have any proof that, the LDS church, I mean, I think the LDS church, if I were the LDS church, I'd be like, these guys don't follow our religion, so to speak. So do with them what you may. So we'll see. Artie wants to know, Scott, do you think there'll be a double trial? And I would say 2 trials. Yes. I think that the cases, although currently joined, that they will ultimately have separate trials. We've talked about this a little bit before, okay? Way back when John Pryor filed a generic, and I mean generic, motion to sever. And most people know that are in this business, when you have a motion to sever, you have to articulate the reasons why you think the case should be severed, okay? And it kind of tips everybody off, which is, I'm going to point my finger at the defendant, the co-defendant in this particular case, right? And where's my motion to sever here? Okay, here we go. It came apart, but the gist of it is, I'm on a motion to sever. This is why I say that Chad Daybell says Lori Vallow did it. As part of the defense, Mr. Daybell would seek to introduce the prior bad acts of both Miss Vallow and Mr. Cox, as well as evidence regarding their relationship and the death of Mr. Cox and the past statements of Mr. Cox. Miss Vallow's prior bad acts would bear upon motive, intent, and plan. In particular, Miss Vallow's alleged involvement in the murder of her ex-husband, who Mr. Cox told police that he had shot, plainly bears upon the issue of whether Miss Vallow and Mr. Cox had an ongoing conspiracy that preceded the core acts alleged in this case. As such, Lori Vallow's previous conduct easily meets the relevant standard for reverse 404B evidence. In fact, this information goes straight to the heart of Mr. Daybell's potential defenses, including any defenses that he did not commit the crimes alleged, that he was not engaged in a conspiracy, and that he had no knowledge of what occurred. The alternative perpetrator evidence is inconsistent with and raises a reasonable doubt of Mr. Daybell's own guilt, such that Mr. Daybell has the constitutional right to introduce the evidence regardless of state's evidentiary rules. Moreover, because Mr. Cox is now deceased and cannot be called as a witness, Mr. Daybell would likely need to introduce statements that Mr. Cox has previously made to the police, as well as others pursuant to hearsay exceptions. Specifically the Idaho Rules of Evidence 801 D2E, which are statements in furtherance of a conspiracy, hence not hearsay, right? We've talked about that before when it comes to this as well. And there it is. That's it. So the motion for severance basically says, Judge, here's my defense. Just like I've been saying all along. Why doesn't anybody ever call me? No, I take that back. Everybody calls me, and then they're like, oh, we can't afford that because, that big chunk of change, let's just say we're going to charge $400 an hour. Then you get multiple attorneys. That's one attorney for a year, $720,000, basically working on this case nonstop. Doesn't include investigators, doesn't include experts. Okay. Anyway, he comes in and he says, Judge, we're going to throw Lori Vallow under the bus. We're going to say what that guy on YouTube has been saying. Chad Daybell's defense is simple. It's easy. And if this weren't a death penalty case, I could go to trial in January. But if you're going to make it a death penalty case, Judge, then I'm going to need more time to go do all this mitigation. But my defense is simple. I didn't know anything what was going on. I was duped, right? Lori Vallow, Chad Daybell can get up and testify and say, you know what? I was in a relationship with my wife. We'd grown apart. I thought the world was coming to an end. She was more into training for marathons. Our kids were gone. We're looking at each other saying, why are we, do we get along? What are we doing looking at each other here for? And all of a sudden, this woman thinks that I'm like the greatest thing since sliced bread, completely idolizes me, and I fell for her. Little did I know that she and her brother are both crazy. And we all know she's crazy, right, Liz? How long did she spend in the state hospital getting restored to not being crazy? We all know, looking at the jury, hint, hint, wink, wink, nudge, nudge, say no more, say no more. We know she's crazy. I'm not crazy. I got duped just like everybody. She's fooled police. She's fooled school teachers. She's fooled family members. She fooled me. And I got duped into all of this. You know who the people that did this? Yeah. Lori Vallow and her brother. And it was a conspiracy, but I knew nothing about it. I didn't engage in any conspiracy, didn't do it. At most, maybe I knew some babies were there on my children. The children were there on the property, but that was afterwards. Okay, so if you want to get me for accessory after the fact, I'm okay with that. But I didn't commit any murder, and I wasn't part of any conspiracy. And oh, by the way, they probably killed my wife too. We know that Alex Cox more than likely took a shot at her, right? All that evidence is going to come in. One way or the other. Inconsistent theory of defenses, throwing somebody under the bus. We talked about it, about the Supreme Court cases that discuss the fact when you have inconsistent theories of defenses and their statements that could be introduced as to one and not the other, separate trials. Bottom line. So, yes, I think there will ultimately be 2 trials. They're going to be back to back. And a lot of the same information that the prosecution is going to have to present to kind of lay out the timeline of everything here is really going to have to, is what Mr. Pryor, John Pryor, is stating that he's going to need. Basically all the stuff from Arizona. They're going to be saying the same thing, right? And I'm telling you, as a defense attorney, you want that other chair empty. You might as well, when I've done those cases, I'm going to point fingers at somebody. I have my chair, maybe an associate, then the defendant's chair, usually put in between us. And then you leave like a space over there. Almost looks like he's going to be there, maybe a legal pad or something up there. And you can point, that's where he is right now. He should be sitting here right now, but he's not, right? And say, that's who did it. The guy should be sitting there in that chair. He's the guilty one, not my guy. My guy's as pure as the driven snow. I said this 16 months ago. That's the defense. There was no conspiracy. I didn't do it. I got completely duped into it. Lori Vallow's defense is, have I told you that I'm crazy? Yeah, that's right. I thought I was this goddess and I could detect these levels of badness, dark spirits. World's coming to an end. Going to select these, 1,400 or 14,000 people. And that's it. Going to start all over again. And it's all up to me. Okay. Ladies and gentlemen, that's crazy in most books. Crazy, crazy, crazy. And Lori Vallow has a pretty good case for crazy because they said she was crazy. Hell, the state doctors said she was crazy. And you may say, oh, Scott, listen, most state doctors, when you send somebody down for a competency evaluation, let alone a NGRI evaluation, it is basically the person can fog a mirror. They know generally what's going on. What's the role of your defense attorney? What do they have to prove? What are you accused of? What's the prosecutor trying to do? It could be simple answers as, they want to send me to prison. What's the defense to do? They're supposed to keep me from going to prison. Okay. What's the rule of the judge do? What is the rule of the judge? What's his role? He decides if I go to prison. Okay. There's some people say close enough. And actually, in today's world, most people aren't familiar with the judicial system. So that's about as good as they can normally get, unless, of course, you watch Crime Talk and then you're a Crime Talk aficionado and you know that's not how it works. So, Shauna wants to know, why isn't the money from the Netflix series paying for this trial? Why would it, Shauna? I don't think they have any. I mean, the son, what was his name? Cody, he was in there. Maybe he got paid for doing it, but why is he going to share the money with his mom for attorney's fees? If he got any, I don't know if he got a single penny, but he thinks she did it. Why would he spend, his money throwing, good money after bad in this particular case? Gloria, good. That'd be a great cross-examine, great closing argument. You don't dig two holes in the background for one raccoon. And remember, that was Chad Daybell talking about shooting a raccoon and then burying it in the backyard on his, I think it was a text or a call to his wife or something. I think it was a text. Yeah. And coincidentally, I think when they dug it all up, although I can't remember, I don't think they found any raccoons in those graves, the pet cemetery that they had back there, which that's even getting a little weird too. I mean, I don't know. Maybe I've just been watching too much of that whole Dahmer thing. But yeah, I don't know. Just even your pets. I mean, I don't know. Tracy Winters, you make me wish I was a lawyer. Why? Because anybody can do this, Tracy? Is that it? Is that what you're saying? Or you think this is very, very interesting? I don't know. Hopefully it is. I mean, but I'm not trying to, let's see here. Good question. Question for Scott. Is there a deadline for the judge to enter his ruling regarding Daybell's motion for to separate the case, the motion for severance? In Washington State, there is no deadline for a judge's ruling. Not normally. The judges would normally rule on the motion as quickly as possible. Here, I think it's a little premature. They may have to have some argument. We have to see what the prosecution says. If they say, Judge, you're right, I think that that's the case, because if we're going to do this case twice, let's just do it twice now, not now and 5 years from now when the case gets reversed because they should have received separate trials. And no, they can't do it. You can be severed, and I've seen it. Had it happen in a trial. It was a big federal joint trial, multiple co-defendants. The judge wasn't satisfied that a conspiracy was a participant was a co-conspirator in the alleged conspiracy when he made his determination, and he severed that defendant off for his own separate trial. So you can be severed in trial if the judge says, oh, yeah, that really sounds like an inconsistent theory of defense. Wow, why didn't somebody raise this? It's, a trial is supposed to be some sort of choreographed theater in reality, right? But it never goes exactly that way once you get there. Like they used to say in the military, your best laid plans go out the door or the window, whatever, up in flames when that first round is fired. Well, it's the same thing in litigation. I literally have had cases prepped. This is my theory. This is ready to go. And something happens at the last minute. Maybe a witness doesn't show up. And like all of a sudden, everything changes. Well, if that witness isn't going to show up, then I'm not going to. Yeah. So it's a lot of things can change. Let's take a quick look at this. Says Jill Burrows is a new member. So obviously you can tell there's a lot of comments going by here. and it's difficult to try and read all of them, but if they catch my eye, do that. And I would note we don't ask for them, but if you do highlight it, like becoming a new member there, Jill, thanks for joining us, Jill. It gets highlighted, and guess what? I will more than likely click on it because you managed to do the super chat, and therefore I will do what I can to make sure your question gets answered to the best of my ability. Claire, I need a chartboard to figure out who is who and who did what. Claire, this is pretty, let me give it to you simple. You got Lori Vallow. I should have my little stick things with little head pictures. Lori Vallow. She was married to Charles Vallow. He was husband number 4. During that time, he becomes quite concerned about Lori Vallow's mental health, saying, this is odd. She thinks that she is a goddess, and the world is coming to an end. At that time, she meets Chad Daybell, her now husband number 5. Charles dies an untimely death when Lori and her now deceased brother, Alex, go over to Charles' house. Alex says Charles came at him with a baseball bat. Police say, oh, self-defense. They then determine later on that, well, maybe that self-defense wasn't so accurate because, well, some of the bullets would have been fired when Mr. Vallow was on the ground. Well, suffered an untimely death. Suffered, I think, some sort of hematoma. Don't quote me on that one exactly, but it was some sort of medical condition where they ruled it to be natural causes. What a coincidence. Lori moves, and I guess I should say Alex dies a little later, but Lori and Alex go to Idaho to be closer to Chad Daybell, who is this writer about doomsday theories, preppers kind of thing, a novelist, if you would. It becomes clear to lots of people that Lori Vallow and Chad Daybell are spending a lot of time together, and Alex Cox, the children disappear. Hold on. I pull up my timeline. I have a timeline of this, but Chad's wife, Tammy, who was apparently quite fit, was training to run a marathon, passes away unexpectedly. No autopsy done. It's not done until after all this mess, after they exhumed her body and ultimately charged Lori and Chad with her death. During that time period, though, shortly after Tammy's death, Lori and Chad get run off to Hawaii. They get married. Oh, by the way, they just happen to leave the kids at home. Oh, that's right. That's when people started getting weird. Like, where's the kids? Where are the kids? Why can't the kids show up? That's weird. Lori asked some of her friends to basically lie. Oh, the kids are here with me here. They're fine. They're good to go. No, they're not. They're gone. Lori and Chad run off to Hawaii, get married. They're there for, I think, a couple of weeks. Ultimately, the state of Idaho says, hey, we're giving you an order to show cause, produce the kids. And they don't. And then they order a warrant for her arrest. And she comes back and bam, here we are. Walker D, do you believe something shady is going on with the lawyers, judges, etc.? I have no proof. Okay. So I'm not going to throw those stones. What I think is going on here, it's just inexperience. And I don't mean that in a bad way. I mean, we've gone out there to Fremont and Madison County and say Frank and I flew out there. Frank, the hardest working man in show business here, the producer, the editor, the writer, all around handy guy. We went out there. I mean, it looks like if you were dropped right into the center of town, it would be like, you have been dropped into the set and just call in central casting for like Mayberry. It's like classic middle America where it's just small town stuff. I mean, I'm sure they have crime down there, but they don't have that much crime down there. I don't think they have that many murder cases. I'm sure they get one maybe once every couple of years, but let alone a double homicide. I mean, triple homicide, conspiracy, weird stuff, crazy people. It's stuff that you just don't get when you're there in kind of wholesome middle America where people leave their doors unlocked. When we were there, and it was just for the day, but the people were so polite. All right. I mean, Frank, am I saying anything I mean, they were just, it was like Mayberry. It was just middle America, central casting, bring it in. Everybody's nice and cheerful and kids walking down the street, riding their bikes with mom and stuff. And I guarantee you walked in somewhere to the main, off the main street to houses that there would have been doors unlocked. I mean, so I think the thing that's going on here is it's just inexperience. They don't get cases that have multiple terabytes of information and DNA and all that kind of stuff. It just doesn't happen that often. So do I think anything's nefarious? No. Now I do have some information, and it's been, what's the word I'm looking for? There's been some issues that have been allowed to been appealed from this matter regarding some alleged pretrial misconduct or something. Maybe some allegations that maybe some of the attorneys or the DA's office were somehow on these like public forum post or chat and maybe commented or something. And that's why there were some arguments about that. Now, I haven't seen that, but I've talked to people, and I've talked to another person that said, yeah, I've seen the stuff. So I'm just curious. I think it's inexperience. You know what I would do? Going back to the whole reset thing, this is what I would do. I'd say, Judge Boyce, he calls everybody out there and says, Mr. Pryor, this is your one chance. You're going to get off this case, because if you're going to get off, now's the time you're going to do it. Okay? And guess what? If you don't get off, you're not getting off this case. You're going to do it for free or whatever you've been paid. And if there's an appeal, guess what? You're probably going to get sued for malpractice because you've all but said you're not effective. You haven't done what a competent lawyer would do on a death penalty case. And your malpractice insurance can pay for the new attorneys or the time that he's been incarcerated because of your alleged ineffectiveness. So here's your opportunity. Would you like to get off the case now? Because now is your time. Yes. Fine. Appoint the public defender to Mr. Chad Daybell, or a private attorney if there's a conflict with the public defender's office, however they work that down there in that neck of the woods. Then you look over there to the attorneys for Lori Vallow and say, listen, okay, you want these documents. I get it. You're entitled to these documents. Everybody needs time to do this. We're not going to delay it. So how much time do you reasonably need to get these documents, to get them reviewed, and be able to comply with the rules of Idaho Statute 19-207? Well, Judge, we need 6 months. All right, I'm going to give you 8 months so you don't come back here and ask for any continuance. And then he's going to say, we're going to set a trial date 8 months out. And he's going to look over there to Mr. Pryor and say, whether you're not going to be here or not, but guess what? We're going to set it 8 months out. So get that new attorney. They're going to be ready to go in 8 months too. You better work with them to get everything ready to go up to speed. Look at the prosecutor. How much time do you need to get your experts? Okay, 6 months. Okay, 8 months it is. We're going to do a trial. We're going to set this for October of some time of next year. There will be no continuances. All motions will need to be filed by, say, March 1st of next year. The court will not consider any other motions unless good cause and a motion for good cause, motion for leave, with a good explanation for good cause as to why it wasn't filed by the filing deadline will be heard. You've all had more than ample time to do this. File all motions, including any motions in limine, which are just motions to say, Judge, we think this may be an issue and we're trying to avoid it beforehand. So could you give us a ruling on it? File all those by March 1st. And that's it. That's it. set the hearings in the public so people have confidence in the proceedings, confidence what's taking place. Look at this. We've learned more in the last week of motions filed about what has been taking place or what has not taken place because we got access to the motions. That's it. We've been completely in the dark. Can you imagine if Lori Hellis, the writer and former attorney who filed the motion to have access to all the court hearing transcripts that have been closed and sealed, all the documents and all the motions that have been sealed from the public, imagine what we're going to find out. My guess is it's going to be incompetence through and through. And I don't mean that to disparage them. I don't think it's incompetence in the sense of a bad way. I think it's just inexperience. Like, we have 5 attorneys in our firm. We can handle the big, complex cases. We've been doing them for years. And one of the reasons is because we had the resources to do it. But if you're a one-man shop like John Pryor, you're still trying to bring in clients, go to court, do this other stuff to make a living, but you think, oh, I got this big old case over here, and it's a complete mess. It's going to take all my time. I'm going to go broke trying to do this case. My advice to Mr. Pryor would be, get the heck off of it now. No matter what happens, it's not going to be worth everything that you are going to be put through. You're not going to be a hero. You're going to go broke trying to do this if you haven't been paid. I don't know what the resources are, but I mean, a death penalty case is a multi-million-dollar endeavor. It really, really is, to do it correctly. I've talked to some of the, I've talked to lots of people. Let's just put it that way. I don't want to go into specific cases, but significant cases where I tell them, I would be more than happy to represent you, but you can't afford it. So go with the public defender's office. If there's a conflict, they'll appoint a private attorney. Hey, you can ask for them. Maybe they'll even appoint me. But there's no way to properly do this case on a private level. Most people can't afford it. Maybe if you're worth 25, 50 million, 70 million, yeah, then you can throw it in. But if you're a working person every day that goes to job, lives paycheck to paycheck, there's no way you could properly prepare for this. And you need to just do what needs to be done, which is say, I want the public defender's office. They're going to have the resources, the experts, the experience, all that. One of them wants to know, Scott, what about Tammy's death? Would Chad deny that too? Yes, of course. I'm sure if he were to get up and testify at court that he would say she was healthy. Yes, I was, I want to repent. I was thinking unpure thoughts about Lori Vallow, but I never would have done anything if my wife, were alive. Nothing inappropriate. It was wrong. I regret it. Look where it's got me today. She's crazy. And the one thing that they always say that I've said for a long time, if you notice, he's never argued for bond. Have you ever noticed that? Because I joke about it, but really what it boils down to is that he's probably safer in custody than out, because all the other husbands died. Well, at least a couple of them, I guess. Coincidence? I don't know. But everyone around her dies. He was safer in custody. So yeah, of course he's going to deny it all. He didn't do anything. Alex and Lori did it. He was a loving husband. Why can't I get this one to come up here? Super chat from Just Jake. I can't get it to pop up here, but let me see if I can. I seriously doubt Chad has any significant money to keep paying Pryor, given that the alleged killer, his wife, allegedly killed his wife for a few $100K. Yeah, I'm referring to the insurance premium. So yes, that's right. And they were living large. I mean, it probably covered a little bit of it, and probably would have covered a little homicide trial, but not a death penalty case, right? Do you think Chad and Lori had this defense planned out before they even got arrested? It seems that way to me. Respectfully, I don't think so. I think Lori Vallow is probably saying there's nothing wrong with me because all the crazy ones never want to go to the state hospital. Trust me on this, ladies and gentlemen. When the defendant is saying, "Ooh, the demons made me do it. I think I need to go to the state hospital. Ooh, the demons made me do it." Competent, malingerer, faker. The ones that are crazy are the ones that you sit in there, have that conversation with, and you're like, "So tell me how this all came about." And you sit there and you're listening, and they're completely straight-faced and what have you. And like, I'm really, really concerned based upon what you're telling me that you're actually appreciate what's going on here. And I'm concerned. And they're like, "Well, I'm not crazy." People have said that before, and I've always been found to be saying, "I'm not crazy." I'm telling you, the crazy ones are the ones that do not want to go to the state hospital to be evaluated. Okay. The lawyers raised it, and why I think that Lori Vallow was in fact truly, and I think probably they'll be able to show, according to the statute, Idaho statute, suffers from a severe and reliably diagnosed mental illness or defect, resulting in the defendant's inability to appreciate the wrongfulness of his conduct or to conform his conduct to the requirements of the law. So I think that is, I think she's got issues. She was down there for 10 months. I said this, a lot of people was like, "Oh, Scott, she's crazy like a fox. She's not crazy at all. She just wants to go down there and have a little vacation." I'm like, "Nah, I don't think so. I don't think so." The resources at a state hospital, regardless of any state that you're in, like our most resources at any government hospital facility, they're limited. They have limited bed space. They have limited dollars. It's usually a teaching school. So if somebody is malingering and faking it, they're going to detect it and boot them out as quickly as possible. That's what I truly believe. Now, do I know this? But it took 10 months. I don't think and when somebody goes down to the state hospital and it takes 10 months to get them restored to competency, they're dealing with a lot of individuals, a lot of nurses, doctors, interaction with staff. They're observing them all the time, even when the crazy people, potentially crazy people, don't think they're being watched and they think they can maybe let their guard down if they're malingering. They're being watched. You can't fake it for 10 months. So, yeah, I don't think they planned anything out. I think that this is just the way it goes. I think John Pryor probably has some good client control over Chad Daybell. I mean, John Pryor, say what you will. I told you I was impressed with him generally at the preliminary hearing. He clearly knows how to try a case. I just think he's in over his head, not as an attorney, but as it relates to resources here. And I don't think he has the resources to do the case correctly. I don't think he has the time to do the case, the time or the resources to do the case correctly. And I don't think the guy should go broke trying to do this case. No good deed ever goes unpunished. And this is the exact type of thing that will drive your practice into the ground, thinking you're going to get something out of it. You're not. Yeah. Crocheting Bammy. How many times can defense request severance after the judge denied it? Seems like a very big waste of money. Well, I can tell you once I had a multiple co-defendant case, and literally every morning. The trial went on. It was supposed to be a 1-week trial, turned into the biggest cluster, you know what, you can possibly imagine. Trial went 3 weeks. At a certain point, I was like, Judge, we need to wrap this up because I had to be in the Middle District of Pennsylvania for something, and we're in Colorado. And I had a case out there at the time. And I'm like, this is ridiculous. But we had a judge who was kind of weak, and he let the whole circus go in. But I literally would get up to court every morning. We would do our appearance of counsel. Good morning, Your Honor. Scott Reich on behalf of my innocent client. And we would move for severance. That motion is denied. We would move we would have a bench conference. All the attorneys would go up there. Your Honor, on behalf of my client, we move for severance. We move for severance every day. It mistried. So we're getting ready to set the new trial date. And the DA, we're all there with all the co-defendants. And the DA says, Your Honor, based upon my experience, I'm going to grant Mr. Reich's request, and we're going to grant his motion for severance. And I was like, are you kidding me? For 3 weeks, I got up here, first thing in the morning, before we left, morning recess, afternoon recess, I got up there and said, I move for severance. At every bench conference, I move for severance. And the DA objected. She looked at me like I had a third eye on my forehead, and the judge went along with it and denied my request at every time. So then I stood there and I said, Your Honor, I object unless the district attorney is willing to state on the record that my motion for severance was appropriate in the first trial. And the judge was like, well, Mr. Reich, we don't need to do that. No, Judge, I just want to know what's changed, because the district attorney kept denying it. You kept going along with it. I just want to know what's changed all of a sudden, Judge, because I've been moving for this. It doesn't. Client ultimately went home, but the point is, you can ask for severance as many times as you want to preserve the record. If you don't ask for it, guess what? It's deemed waived for appellate purposes. Super chat here, but I can't. Frank, can you maybe put that up there? I can't see. Catherine Liu, right up there. Yep. Look, if your top screen, it's highlighted there. Oh, there you go. Oh, sorry. Okay. Do you think that Lori and Chad, who had their own little cult with Death to Zombies, could be deemed incompetent for that reason? Well, Chad, it's never been raised. But, like I said, what is somebody that's not like, I know they don't have not guilty by reason of insanity in Idaho, but it's somebody that suffers from a severe and reliably diagnosed mental illness or defect, resulting in the defendant's inability to appreciate the wrongfulness of his conduct. So crazy. You have to appreciate what you're doing. If you think you're doing something evil because the demons made you do it, the dark spirits made you do it, and you truly, truly believed it. Truly believed it. Not just, we have this little club, we have this little following, we all meet, we think the world's coming to an end, so we do some prepping together. That's not insane. You have to truly, delusionally be diagnosed with something, i.e., like schizophrenic, right? That's normally where an NGRI comes up. And I know they don't have an Idaho, so don't put it in the comments, but that's really normally when it comes up. Is, like schizophrenic. Oh, yeah, the guy's been suffering from schizophrenia since the age of 15. Man, if he's not on his meds, he thinks everybody's a demon. And that's why he beat up the police officer who was coming at him. He thought it was a demon. NGRI. Because he truly believed the person coming at him was a demon. Not just because he didn't like him. Not because he was having a bad day. Not because he was having a meltdown. Like, oh, everything's going wrong. Nothing goes right. That kind of thing. No. It doesn't. You have to have that severe and reliably diagnosed mental illness or defect. Mental illness or defect. Think about it. You got to be really diagnosed with something good, not just, I got a little I'm a little down today. I suffer from a little depression, little blue today. No, that's not it. That doesn't cut it. Let's see here. Squeaky wheel. Chad will try and claim that Lori and Alex buried the kids there without his knowledge. Nobody on the jury is going to believe it, but that's just about the best defense. Yeah, I can't disagree, Squeak. I think you pretty much nailed it. And yes, just because it's defense doesn't mean it's going to work. And I've said this many, many times over my career. Why are we going to let the facts get in the way of a good defense, ladies and gentlemen? Oh, no, we're not. All right. If you can raise a defense and argue the reasonable inference from the evidence or the lack thereof, that is a legal defense under the law, ladies and gentlemen. That's right. So, gonna deny it. When were those bodies put there? That's what you're going to ask the prosecution witnesses, right? Well, Mr. Prosecutor witness, Mr. Cop man, Mr. Policeman, when were those children placed there in those graves? Well, we can't say for certain. Oh, you're uncertain. You're uncertain as to when those graves were dug. Well, in the course of your investigation, did you happen to look at the travel schedule for Mr. Daybell? Did you notice if he was out of town during that time? When he left the house during the day? So you didn't check into that. Or if you did, you noticed that he was away from the house. He wasn't there at the house 24/7 during this alleged time period. Oh, and then you get up and argue in closing statement. Well, you guys had already searched the property. The property had been searched by people, right? They've been to the property before. And think about it. If you have an acre of land, Frank, can we pull up the little video that we have, the little drone flying over the Daybell property? Now, it's not huge. It's not like we're talking the guy's got 400 acres or something out the back. But here it is. You can see it. It's right over there. Let me see if I can take old squeaky wheel down here or not. This is facing east. That's property to the right. And then to the left, it should turn around here again momentarily. And then we'll be able to zoom into the property. But you can see it's kind of open out there. Do you think everybody goes there and checks their property every time they come home? So you got this big thing of property right here. Now, I don't think Chad Daybell owns that. He only owns kind of from the road here to the right to where there's a cross in the road, a T in the road. And that's his property to the right. You got the barn. You got kind of the property line goes to where that tree is on the right. And obviously to the fence here. And there's a fence line about halfway down the road there. Not big. But I think you would say, and probably the people in Idaho would say, if I have that parcel of land, it's not like I'm going to go checking to see if there's somebody has dug up on my property, particularly if it made it look like it. I'm not trying to make excuses. I'm just trying to say what the defense is going to argue. I mean, every case, I won't say every case. As a criminal defense attorney, I have won cases that I should have lost. Lost a couple I thought I was in the game on. Okay. But I have won a lot of cases over the years where I should have lost, but we went to trial and the prosecutor made a mistake. Maybe a witness didn't show up. Maybe that witness added just a little something different than they added before. And you can get up and say, oh, isn't this convenient? You just happened to make all this up for trial here. And isn't it true since then when you said nothing happened, now all of a sudden you guys have had a falling out and you're going to say anything you can to say that he's a bad, bad man. Isn't that true? Oh, no, I wouldn't say that. I'm not lying. So you just never know. Okay. Now, the prosecution should win, right? They have the heavy burden, the burden of proof beyond a reasonable doubt to each and every element of the defense charged. And if the prosecution in the Lori Vallow case was truly ready, 5 attorneys working on this case, 5 attorneys, full-time, probably mostly full-time, but 5 attorneys, think about it, plus support staff, plus police. They should be ready to go. They should literally say, Judge, you want to set this thing in 2 weeks? We'll have our people here. We'll be ready to go. Because that's the burden the prosecution has. This thing should be boxed up, ready to go. I mean, literally, they should have they write out their little notes here. Opening, and they'll have that designated. What's their theory? What's their theme? First witness. They should have every witness by this point outlined as to what order they're going to be called in, what key point they need to get out of that person. Was it some sort of observation? Are they a foundation witness so that they can introduce a piece of evidence either through that witness or through another witness, but they're the ones maybe found it, and they have to, establish that chain of custody, so to speak. But the prosecution should have all that laid out by now. Each witness. This should be day one. This is what we plan on day one. We're gonna do seat the jury. Then we're gonna ask to take a break and begin fresh on the first day, whatever day they get done with the jury. We're gonna do opening statements. Judge is giving us an hour. They're gonna do their statement. So probably get to the lunch hour. First witness. They should have everything laid out. They probably don't have every question laid out, but if there's an area of law that you're uncertain about or something you want to do, you put a little bullet point. I want to make sure I get this in. You have your little checklist, your evidence checklist. Here's the photos. Here's the audio. They should have that all laid out by now. It's not something you do the night before trial, at least not on a big case, right? We're not talking a little municipal court case where there's 3 pages of discovery. We're talking a case that has so much evidence. And you got to coordinate all these witnesses. Fortunately for the prosecution, most of them are law enforcement. So they're easy to get a hold of. But there's always somebody that's going to be on vacation. Oh, they're going to have training that day. Mother passed away, sick kid, you name it. Something's going to come up, and you have to be prepared for those types of things. So there you go. I hope that helped explain the Lori Vallow, Chad Daybell matter as it stands today. I'm sure it will change. Something will change tomorrow, no doubt. So, guess what this means? It means we have to go to our Patreon show. For those of you who aren't familiar with that, if you would become a Patreon member, well, you have a show with me and Frank, the Harrisburg Man Show business over here. But you get one added feature. Well, actually, multiple added features. If you become a Patreon member, you get a lot of cool free stuff like trial guides, evidentiary guides to say, oh, you can look and say, oh, that's hearsay. Oh, no, that's not hearsay. That's an 801 D2E statement that Scott has talked about. And I know that's a statement made in furtherance of a conspiracy and therefore not hearsay. Okay. So you can do that. That'd be good if you become a Patreon member, and you can call in. And that's right. You see that? That's the Magic 8 Ball. We're going to ask the Magic 8 Ball some questions tonight. See if the Magic 8 Ball concurs with my predictions that there will be severance. And I don't think that we're going to do a trial. I think that's going to be the question today. Dear Magic 8 Ball, are we going to have a trial in January for Lori Vallow and Chad Daybell? I think it's going to say leaning towards no. Okay. So anyway, I want to thank everybody for watching. Subscribe if you haven't. Like the video if you do. Please leave us a comment. Come be a Patreon member. We got cool CrimeTalk merch. Next couple days may be a little sketchy because not sketchy, but I'll be doing some traveling. But we're still going to bring you a show because why you say, Scott, take some time for a break. No, you know what? I went on a quick little vacation, went to Nantucket for a birthday celebration, and I took, 2 days off, Frank? 2 days off. 2 days off, which means I didn't upload. And you know what? I missed setting a new record on the number of podcast downloads because I got weak and took 2 days off. I've been working 7 days a week. but didn't do it. Missed it by this much. I am not going to let that happen again. So anyway, thanks for watching. Have a wonderful day, not just a good day, and we'll see you next time on Crime Talk.